The Court of Appeal, Rivers decision, has nullified a previous judgment by the Rivers State High Court that expelled Martin Amewule and 24 others from the Rivers State House of Assembly. A three-member panel of the appellate court, while sitting virtually in Abuja, held that the lower court lacked the jurisdiction to grant the order on May 10 that expelled the lawmakers. Arise correspondent Godfrey Eshemoge has more.
What has been a long-drawn legal battle involving Martin Amewule and 24 other Rivers State House of Assembly lawmakers reached a crucial point as the appeal court finally gave its verdict. The lawmakers, who are FCT Minister Nzeakor's loyalists, were stopped by the State High Court from parading themselves as members of the Assembly, having defected from the PDP, which is the political party that sponsored their elections. The court order followed an earlier suit filed by Honorable Victor Okojumbo, who subsequently emerged as a speaker. Okojumbo is a perceived loyalist of the current governor, Sim Fubara. A three-member panel headed by Justice Jimmy Bada, sitting virtually from Abuja, says the decision of Charles Wali, a judge of the Rivers State High Court, on May 10 to declare the seats of the 25 lawmakers vacant was clearly a case where the court was acting beyond its powers. The Justice Bada-led panel cited Section 272, subsection 3 of the Nigerian Constitution, which says it is the Federal High Court that has the authority to determine whether a seat of a House of Assembly member has become vacant. Specifically, the Constitution says the Federal High Court has exclusive jurisdiction to ascertain if such seats have indeed become vacant, and not the State High Court, as in the case of Rivers State. It is left to be seen if the judgment will be appealed at the Supreme Court to determine it once and for all. Godfrey Eshemoge, Arise News.
Meanwhile, the opposition Federal Lawmakers Coalition, G60, have rejected the ruling, saying the sacking of the Rivers lawmakers remains valid and has not been nullified. The spokesperson of the coalition, Ekine Ugochinyere, insisted that the pro-Wike lawmaker seat remains vacant.
What point are we trying to make? That the seat of the 27 lawmakers have been declared vacant, and there's no judgment that have quashed that declaration of those seats vacant, and there's no court anywhere in Nigeria that have decided that they are cross-carpeting from PDP at the time there was no division to APC is legal. And let us be mindful of the conversation we're having in the public space. Are we not saying because of the voting ambition of one man that our constitutional democracy and constitutional march should be retarded? That somebody is fighting and because of his desperation, he gets some young men in the House of Assembly to jump into another political party when there was no division in their desperate way to force Fubara out of office unconstitutionally. And suddenly they realize the stupidity in their action. And then suddenly they are running around all courts in Nigeria so that our court will say what? Our court will void those provisions of our constitution. Is that going to be a progress? That lawmakers can jump ship at any time they like and then remain in office, even when there's no prevailing need or reason for that. That is what we are fighting for. That is what this matter is all about. An attempt to undermine our constitutional march.
Joining us now on this show are two lawyers, Henry Ekine from Rivers State and Fred Nzeakor, here with us in the studio. Thank you very much, gentlemen, for joining us. Well, I mean, the matter speaks for itself. The key issue here is jurisdiction.
Absolutely.
And the Court of Appeal says the lower court had no jurisdiction in the matter, which is very important. But I would like to hear from both of you, one after the other, your interpretation of the ruling and the implications for politics in Rivers State and for the validity of the action taken before now by the Victor Jumbo three-man House of Assembly. Let's start with you, Fred Nzeakor, here in the studio.
Thank you,
and then we'll come to you.
Thank you, Dr. Abati, and thank you for inviting me on this matter. The issues are, yes, not only the issue of jurisdiction, which is at the root of the matter. We also have the issue of the fact whether the gentlemen the lawmakers are still members or not. But when you look at the issue of jurisdiction, it is very clear and straightforward. We operate constitutional democracy and we abide by the rule of law, guided by the Constitution of the Federal Republic of Nigeria, 1999 as amended. And the first alteration that was done in 2010, specifically in section 272, subsection 3, specifically said that the Federal High Court has jurisdiction to determine whether any seat is vacant or not of the House of Assembly member or governor or deputy governor. And that is an extension of section 251, which also stipulates all the functions of the Federal High Court and the areas where the Federal High Court has jurisdiction. Now, the question now is the Court of Appeal has rested the issue of jurisdiction in a manner of speaking. And the Rivers State High Court that said they should not parade themselves as members of the House of Assembly pending determination of the substantive matter. There is a substantive matter before the Federal High Court, Justice Okorowo's court at Abuja. The matter is still alive and there has not been any decision on that. The one that the Court of Appeal looked into was the matter that was decided by the Rivers State High Court under Justice Charles Wale, which says that those gentlemen should not parade themselves as members of the House, invariably declaring their seat vacant. And now the Court of Appeal has straightened it up and said the court does not have jurisdiction to dive into that matter and then give any substantive issue. As we usually say in law, that you cannot build something on nothing and expect it to stand.
But
so,
UAC versus
yes, so if the court does not clothed with jurisdiction, it is expected that whatever judgment or opinion or order given by that court should be a nullity, which is, of course, what the appeal court has said. But the substantive issue now has not been determined. And what is the issue? Are these gentlemen still members of the House of Assembly or not? That matter is still before Justice Okorowo at Abuja and has not been decided. And in Justice Okorowo's court, there's an affidavit sworn to by Martin Amewule, which is in the public opinion, in public domain, an affidavit that they have decamped from PDP to APC. Of course, it is by the provision of the law, it is the court, the Federal High Court, that will now give a finality on that, whether their seat has become vacant or not. And that substantive matter has not been trashed by the court. That is where we are as at the moment. What the Court of Appeal has said is straightening up the issue of jurisdiction. And the Court of Appeal did not jump into the issue of whether they are still substantive members of the House or not, which of course is the jurisdiction and that is under the authority of the Federal High Court. We are waiting for the Federal High Court to decide on that before the Court of Appeal cannot be activated if the men so wish to go on appeal. That is the matter as at now.
Okay, Henry Ekine, let's have your own interpretation of this development in Rivers State and whether or not Section 191(1)G, is self-executory, because that's the basis on which, certain gladiators in Rivers are saying, oh, they've been automatically, you are no longer, Okay, maybe you take that. It looks like we don't have any.
Yes.
Can the politicians be the ones to pronounce that Section 191 is self-executory?
Yes, 1091G. Dr. Abati.
No, 191.
109.
109.
Yes, 109.
109.
Yes, 1091G.
Okay.
Whether it is self-executory or not, some people are giving it all manner of interpretation. Some said because the provision has said shall lose their seat, they feel the use of the word shall has made it self-executory. But there is a proviso in that section 1091G. That proviso is important. Because of that proviso, somebody has to make that pronouncement. And who is that fellow? A judge of the Federal High Court. So if they said it is self-executory.
Not to Ugo Chinyere.
Not to Ugo Chinyere, not to anybody. It is the Federal High Court judge that we have to. And that is why we are talking about the matter before Justice Okorowo at Abuja. That if that court has made a pronouncement, then we now take it from there. Otherwise, the section 109 sub 2. Section 109 sub 2 has clothed the Speaker of the House the authority to declare their seat vacant once they jump ship, and which the factional speaker Edison here did at the right time on 13th December 2023 and declared their seat vacant. What is now left is because the issues have been joined. These people are now saying, we are still members of the House. The Speaker is saying, you are no longer members of the House because judging by the provision of the Constitution, your seats have been declared vacant on account of your defection to another political party. Because there is not the party with which you won the election. Now, an arbiter must come in, and that arbiter is the Federal High Court. The Rivers State High Court tried to judge on the matter, and the Court of Appeal has said, no, you don't have jurisdiction to do so. It's only the Federal High Court that has jurisdiction. So we are now waiting for the Federal High Court to do that declaration. But there is one issue that is still hanging, and that is, who has the burden of proof? Who? The onus of proof is lying on those who assert. And who are they?
Who asserts must prove.
Who asserts must prove in evidence. And who are those who assert? They are the people who said they are still members of the House while they have jumped ship. The court has said, the Speaker has declared their seat vacant, and they are saying, no, we have reasons. They will have to go to court and adduce those reasons, which judging by the proviso of section 109(1)(g). And if they fail to prove that there are reasons for defection, then the court will declare their seat permanently vacant.
We understand we have Henry Ekine now. Let's hear from him. Henry Ekine.
Yes, Dr. Abati. Good morning.
Please go ahead. Your own reaction to the ruling of the Court of Appeal.
Okay, thank you. The Court of Appeal simply and directly held to the effect that the High Court of Rivers State lacked the jurisdiction to make the order that the Honorable Justice C.N. Wali made with respect to the former members of the Rivers State House of Assembly, led by Martin Amaewhule, and then 24 others, restraining them from parading themselves. That's public knowledge already. So apparently what that meant by the elementary principle of law, where a court lacked jurisdiction, then of course the entire proceeding and even the orders and judgments, however brilliantly made, or even intelligently made, go to nullity. So that's what the Justice of the Court of Appeal gave effect to. But my concern really here is the interpretation that appears to be on different ends, but we have to put some, I think, fair, straight interpretation with that regard. The crux of the matter with respect to the avoidable and unnecessary orchestrated crisis in the Rivers State House of Assembly is to the effect that some members of the Rivers State House of Assembly, Martin Amaewhule and 24 others, voluntarily, willingly on their own, without any prompting by any other person, decided to leave the House by their action. And what was that? They chose to defect, to denounce the political party that sponsored them to that House. And then the provision of reconciliation is very clear in that regard. And these issues are already sub judice in a number of courts. Even in the Federal High Court, that the Court of Appeal has just held now, that is the appropriate court to determine the questions with respect to cessation or vacation of office of members of the legislature. So the decision of the Court of Appeal yesterday, apparently to me, and I think that should be the right interpretation, is precisely and principally with respect to jurisdiction. And then I haven't held that and haven't also nullified the order that Honorable Justice C.N. Wali made. It meant that order has been set aside. That's, of course, clear also in law. But one other thing is, we have to remember that Honorable Justice C.N. Wali still seized with the substantive proceeding that is subsisting in that court. So the effect of this decision of the Court of Appeal to the effect that C.N. Wali and then the High Court of Rivers, they lacked the jurisdiction to entertain that matter, it will mean that on the return date, that the next adjourned date, then of course I would expect, not preempting the court anyway, since as far as that court is concerned, that matter is subjugated in that court, then the court will return on their next adjourned date. And then I expect that the needed thing to be done at that point is that the appellants before the Court of Appeal, who are the defendants before the High Court of Rivers State, will draw the attention of the court to the effect that the Court of Appeal has made this clear judgment that the court lacked jurisdiction. And I would expect that the court will, based on the principle of stare decisis, and then, also rather of judicial precedent, or respect of the court, on the decision that existed, presenting before the court, then the court will have no option but to respect that decision of the Court of Appeal, and then hands off. But that will be only in respect of the matter that Okojombo and others had brought before that court.
All right. Coming back into studio, so many moving pieces apparent here. I know you've emphasized the fact that substantive matters stand. What are the options available on the table? Because this is a chess game as far as I'm concerned. So the next move now is in the court of the appellant. What are their options?
The options on the table is that the men are still not members of the House of Assembly. That is the fact of the matter, because the substantive matter has not been determined by the court. What the Court of Appeal has done is to straighten up the issue of jurisdiction. Now, nobody will now go and waste one's time at the State High Court on this matter anymore. They have to all empty themselves into the Federal High Court. And there is a Federal High Court that is already sitting in judgment over this particular matter, and that is in Abuja before Justice Donatus Okorowo. So we expect that they will all go to that Federal High Court, argue their matter, argue their cases, and then try to convince the court the reason why they decamped. Otherwise, if they fail, then their decamping will now become a fait accompli, that they are no longer members of the House of Assembly. And of course, except if the matter has been dragged up to Supreme Court, which of course we expect that the matter will get to Supreme Court. But on the surface now, the court is still yet to make pronouncement validly on the issue, the substantive matter of their defection.
Do you think we should have a constitutional tweak where we remove those provisos? Because literally, in other climes, once you defect on the platform that brought you in, you lose your seat and you go and fight for the seat again on the other platform you want. So don't you think, because you know when Nigeria makes laws, we put in a lot of proviso because of mischief. That's just exactly what happened with the new INEC Act leading up to the last election. It was when we started to interrogate the act that we saw too many provisos. That's when INEC started upholding, that the B-verse is not a be-all, a result is not a must, it was dedicated on the IREV, and all of that. But they told us these were the game changers. So we had to now start juxtaposing what was written in the act and what was being implemented. Don't you think we should just pull out these provisos? That's the question I have for you.
If you pull out the provisos, you are no longer allowing human beings to operate as humans. Because the whole essence of the proviso is because we know that we are all human.
So we
know that we are all human.
So there is always, lawyers can make money.
No, there's always a way of ensuring that, because law is not put in tight compartment. You can't put in tight compartment. There will always be what we call exception to the rule. Those exceptions to the rule are all loaded in the provisos. Take, for example, there is crisis in a political party, which, of course, you know that there are always crises in political parties. And if those crises get to the point where the legislators are not allowed to legislate or do their legitimate work, then that is where the law will now come in to protect them to decamp to another party. But when there is no crisis and they decide to generate the crisis by themselves just to suit their innuendos, then that is where the law will also catch them.
Knocking out these provisos, because we now have a country where politicians can have their reign over the judiciary easily.
There are so many things that
where
need to be adjusted.
They can use to manipulate.
There are so many things that need to be adjusted in our laws, Rufai. And that is why we keep saying that there are so many loopholes in 1999 Constitution. Even as bad as it is, the good ones are not being implemented. That is the challenge that we have. Because of when people begin to talk about the mind, that you need to restructure the mind. How do you restructure the mind of somebody who is out to commit mischief? These are the
so you
now make the laws to be able to capture anybody who fails to follow the due process. That's what the law is all about.
I would like to come to you in Port Harcourt, sir. These provisos now have become the albatross of this law. I mean, if somebody defects, he should be able to lose his seat and go back But the lawyer is saying otherwise. What are you saying, sir?
No, Ruva, it's not any constraint at all. The professor, like the guest in the studio, has provided, explained. The question we have here has been interpreted by the Supreme Court, and that's what happens when a constitution, anywhere in the world, when the constitution is extant with respect to any provision, and then there is any, if you like, misinterpretation or misconstruction of that provision, then the courts, and in this case, the apex court in this country, has given clear interpretation of what the proviso to section 109, subsection 1, paragraph G, clearly is. There is no longer confusion in this country as to what kind of fragmentation or splittering, or if you like, crisis in a political party that would have justified any legislator to defect and move from the political party that sponsored that legislator to another political party. So we do not have any such situation, except it's orchestrated, as we have in Rivers State, deliberately created. And like he said, I agree, it is the party who had defected that usually, even the case in Ondo then, it was the party who had defected that had the crisis. Yes, I mean, that had the crisis to justify his defection. And the concern is clear. Subsection 2 of section 109 requires just one more action to be taken once legislators defect.
No.
And I must say here, it doesn't require the court to do the declaration, Rufai.
Okay, but...
It was the court. There is no court that is required in the Constitution to do the declaration. It is the Speaker, the presiding officer of that legislative house.
No, but it must also be backed up by a federal high court, like you were saying, that the judge must also ratify it. And that's why I'm coming back to you. See, there are many cases that people have found this proviso. Look at the case of a senator that decamped from YPP recently and moved on to the APC and nothing happened. And the YPP couldn't go to court to implement it. They just made noise on the fringes, and that was it. What would you like to say about that?
Yeah, that particular case is like the driver parked the car in his garage. That was what it looked like. The driver parked the car in his garage. Because where's YPP outside the senator? That is the question. He is more or less the de facto leader of the party, and once he now decamped, the party more or less
but the chairman of the party
became comatose. No, but yes, chairman is different.
Yes.
Who has been funding?
That I want us to clarify.
Yes.
And I'm coming to you first, Henry Ekine. Now, what is the implication of this latest ruling for the governance process in Rivers State? Let's leave the law. What is the implication for the governance process?
Yes. Apparently, the implication in the first instance is that all matters subsisting before the High Court of Rivers State have suffered that demise, if you like. And it means that the next adjourned date of any of such matters, because I do know, Bati, that there are matters that are subsisting in some of the courts in Rivers State, that's the High Court of Rivers State, really. So one of the implications directly is that there is going to be either a discontinuance by those who had brought those matters before the court, or the court can suo motu on its own decline jurisdiction on those matters, but this would only happen in next adjourned date. It is important to express this as well, Dr. Bati, because some have thought here that there will be direct impact, or if you like, effect of the decision of the Court of Appeal to the extent that all those matters in the High Court of Rivers State have died naturally. But I make a statement here that there would have to be another step, that on the next adjourned date, those matters will come before those courts, and then the courts will take the appropriate step, like either by the court itself or the claimants there will draw the attention of the court and discontinue. Or in some cases, if the claimants there fail to discontinue and then the court didn't exercise that suo motu power, then the respondents or the defendants in those matters before the Rivers State High Court will raise this issue of the decision of the court. So that's one first effect. Then the next is that, of course, clearly it nullified the declaration, the injunctive order by CN Wale to the effect that that order is null and void. And without taking it away from the appellants as a sort of victory to them, they will now arguably be able to say, oh, they can still refer to themselves as, at the time being, as members of the University House of Assembly. But don't forget, like we just mentioned here, that there are a number of subsisting matters, including the one that they instituted in Abuja. That's the one the guest in the studio is referring to before Okoro. They themselves went there to clarify their status as members of the University House of Assembly. Outside that, I know that in the Federal High Court in Port Harcourt, there are at least two matters I know clearly that are subsisting in that court. One by civil society organizations in Rivers State, and then another by, I think, one of the political parties and others. And then those matters are going on. And that's where I have my concern as a lawyer, even though it's my primary constituency, the judiciary. We expected that by the mode these matters were commenced, which is originating summons, that some of these matters should have ended even before we got to this point. And I would imagine also that with the decision right now, the confusion in the state, that the judiciary should step in to be more pragmatic. We should experience some sort of judicial activism here, that the justices of the Federal High Court, who now are the courts vested with the appropriate jurisdiction, should do the needful and quickly close out this matter. What's there that is difficult? Processes have been filed and it's affidavit evidence. But we know what is happening, Dr. Batian Rufai and those in the studio. You every day the matter comes up before the Federal High Court, even the appropriate court, you see motions filed by all sorts of persons, including the defendants, and even other parties seeking to join.
On that note,
I'm aware of applications.
Henry Ekine, thank you so much for your time here in studio, Barrister Fred Nzeakor. Thank you so much for your time, your contribution to this issue. I know for a fact we haven't heard the last of it, and we look forward to more details as it develops.